the 18th of March 2024, an important video, real true education, not fake news, wind farm nuisance. Good morning, folks. Now, I want to show you this book here. It's dirty and it's ragged and there's pieces stuck in it here for all kinds of things. And using this book, I've been able to advise people, and I don't give advice on legal matters. I'm not a lawyer for you or anyone else, but I can give what has happened, and this has pointed people in the right direction. It's The Principles of Irish Law by Brian Doolan, and it's dirty and it's rough and ready, and it's Gill and Macmillan, and it's a good law book. I strongly advise that there's a small version and a big version. Now we're going to look at private nuisance. Now there's a public nuisance that's on the roads, but I have to keep it short. A private nuisance is a substantial interference with the comfort of neighbouring occupiers according to ordinary, sober, common sense standards. Have you that? I'll talk a little louder, folks, if you don't mind. A private nuisance is a substantial interference with the comfort of neighbouring occupiers according to ordinary, sober, common sense standards. Now, I'm getting at here is this decision that's after coming out on wind energy, which has afflicted the lives of many people all over Ireland, particularly here in Kingscourt and particularly in Tier Worker, Kerrycavan. Whether the action amounts to nuisance is judged in terms of reasonable give and take between neighbours. So there has to be a bit of reasonable give and take. I mean, I can't be complaining in the month of July of neighbouring farmers cutting silage. They have to cut their crops. I only put up with it during the daytime. It doesn't bother me at night, and it is an interference with the lovely atmosphere of the June good weather. But it's necessary. It's part of our society, and it's part of I do it as well. So we have to be allowed to produce. So it's reasonable give and take, and that is a great law. I love to hear that sort of law. An occupier cannot use the property in such a way as to impair the enjoyment in a substantial manner of another's property. Get that now, another's property. The law is not concerned with trivial, fanciful or exaggerated inconvenience, per Hinchy J. in Mullen v. Haynes in 1972. Hinchy J., that's Judge Hinchy, in Mullen v. Haynes. Generally, this substantial interference is proved by repetitive and continuous acts of nuisance. You see, that's where the silage cutter doesn't have to worry. It's not repetitive. It only goes on at a particular time of the year. Likewise, I'm sure if you had a clay pigeon shoot 3 times a year beside you, well, it's only for a while, and if they let you know about it, like that. And putting out slurry is another example where it's seasonal and it has to happen. So it's a substantial interference. A cranky person would not prove this. It's an ordinary person. And the big thing here is repetitive. See, the windmills are repetitive. They never stop, night, noon and morning. Private nuisance is not actionable per se. There must be proof of inconvenience or damage. See, it's not just per se means simple actionable. There has to be proof of inconvenience or damage. Personal injuries cannot be sued for in private nuisance. So if a tree branch falls on me and breaks my arm, that's not a private nuisance. Personal discomfort is actionable, provided it's substantial. That's good old law, common law, and it's 800 years of age. The occupier of property is under general duty to neighbours to remove or reduce natural or man-made hazards, that's wind farms, which occur on the property. This duty is based on knowledge of the hazards, ability to foresee, and consequences of not checking or removing it, and the ability to abate it. Right? So they should foresee it. It was told to them during planning, just told to the wind industry, this is going to cause misery to people, and they refused to listen, and the planners refused to listen. Okay, so I'll just read that again. This duty is based on the knowledge of the hazard. So if something occurred accidentally, for example, if I had a crow scare up the field and I went off every hour to frighten the crows, but I went off my holidays and something went wrong and it started going off every 10 seconds, Well, that would be a nuisance if I was on holidays. But then it wouldn't be repetitive enough, you see. It would have to be going on all the time. The knowledge hazard, ability to foresee the consequences of not checking or removing it, and the ability to abate it. So if they can't abate the wind turbine noise. The lawful occupier of a property is the party who can sue in private nuisance. So it has to be the owner of the property. It's not the person, it's the property that's affected. Even where that property is not the owner, even where that party is not the owner, it's the occupier. So if you're rented in the place, because private nuisance offends against enjoyment of the property and those with an interest in the property, but not in possession, cannot suffer the inconvenience. So if I own a property down in Kerry, I can't suffer the inconvenience even though I own it. You understand? It has to be the occupier. But the owner-occupier is doubly covered. Generally, the creator of the nuisance is responsible in law whether or not that party is the owner of the property in which the private nuisance is committed. A landlord may be liable in certain circumstances. Okay, we'll skip there. Instances of private nuisance. Thus, private nuisances take a large variety of forms. Noise, heat, smoke, smell, dust, vibration, soil erosion, branches of trees, damage to foundations, fumes, sewage, dangerous leaves and blasting operations have all constituted a nuisance, and now wind farms do as well. So we needn't go any further there. Now I'll just read you about barking dogs, because you might ask me. Where on a complaint being made to the district court, any person appears to that a nuisance has been created as a result of an excessive barking dog, the court may order the occupier to the occupier of the premises in which the dog is kept to abate the nuisance. That's dogs, right? You have law there. You don't have to sue in the same way you would with the windmills. You have to go to the High Court. Now we're going to show you what I'm coming at. The Irish Independent on the 16th of March 2024. Landmark decisions open the possibilities of compensation. An article by Caroline O'Doherty. The Attorney General is studying a landmark High Court ruling on the noise from wind turbines that could have implications for the operation of existing and future wind farms. Now, this has nothing to do with European law directly, but it has a lot to do with it indirectly. Now, officials from two government departments, Housing and Environment, have joined the Chief Law Officer in examining the judgment. And this is the law officer that told the government about the implications of the family referendum, and they refused to let it be known to the public. What they're doing now is they're circling their wagons, particularly the government is anyway, to see how they can beat us in this ruling. It's not to try and look after people or bring out new law to make it easy for people to get justice. No, it's to try and defeat us, you see. That's what they're doing. And they're trying to amend the Planning and Development Act because of things that I and a few others have done. Wind Energy Ireland, which represents most wind farm owners in the country, also has experts scrutinising it. They're scrutinising it as well. But folks, you can scrutinise it all you like. I told you this and you refuse to listen. The ruling found that turbine noise, even if within planning regulation limits, could be categorised as nuisance. So you get some young one, which happened here, young lassie from South Africa decided my wind farms were not a nuisance to me. I'm here all my life and it wasn't a nuisance to me, and they were trying to claim, oh well, that's it, you can't sue, that's the planning. This court ruling is it doesn't matter. It's whether there's nuisance or not, and the planning is not of consequence. Now, that opens the possibility of compensation claims by people who say noise from wind turbines interferes with the enjoyment of their homes and daily lives. And that is something I've been complaining about here, folks, and my neighbours are complaining and all of that. Okay, so you see how it has destroyed the wee farm I kept here when I was away working and everything. Lovely little place, and they put me that I can't build a home. I had a planning permission for a house in 2006, and I couldn't go ahead because I knew this was happening. So I knew this was happening, and the wind industry knew it was happening, and the law there in that book says it's what you could reasonably foresee. So it could be reasonably foreseen, and I was reasonable in not building because I didn't want to suffer this with my family. In the case that gave rise to the ruling, nuisance was proven by two couples who lived close to the wind farm in County Wexford. The case heard that they were constantly stressed and sleepless, that one of the couples split up, you know. There was no worry on behalf of the Irish government that this couple had split up and had their relationship destroyed. Yeah, and then they could come along and pass a referendum to make a marriage a durable relationship. And there was no concern for these people because they weren't on the woke side of woke, right? So these couples split up largely because it is now a one. It is now it is and no, sorry. The case heard they were constantly stressed and sleepless. That one of the couple split up largely because of it, and one party was left suicidal and remained under the treatment for depression. It's like a big tumble dryer. It's for all the world like a big commercial tumble dryer running in your bedroom. That's the best way I could explain it. And there's also a thing called infrasound, low frequency sound, that you can't shut out. It comes up through the pillows. And couples, the Canes down in was it Long? Where were they over? Somewhere down in Longford, I forget now. No, it's common. We're suffering this, and the wind energy told them you can hump off. We'll build more of them, right? Now, treatment for depression. Now it doesn't. If I don't get depression too easily, but if you're after buying your wee place and it looks nice and they put this in front of you, it is depressing. High Court Judge Miss Justice Emily Egan. Now I think it's a big risk who you get to judge, but this Emily Egan, I read her ruling and I'm reading it again, and she really done everything she could to be as objective as she could. So cap off to Judge Emily Egan. Found that they established their right to receive damages from the company. I don't know will they be able to shut it down, but they got the right to receive damages. This is wind turbine noise that an objectively reasonable person should not be expected to tolerate, she said. So there's the law, as is in the book. You see, she's getting probably straight out of Doolan's book. I mean, well, it is any good book is the same. A second part of the case will consider the level of damages due and significantly whether an injunction can be granted against the wind farm. Can they be shut down altogether? If an injunction is granted, it may come in the form of restrictions of operating hours rather than complete stop of operations. I don't know why the paper can say that. Sure, if it's given noise in the day, or if you want to go out in the daytime, I don't know where she gets that. The ruling is the first on the issue in Ireland and comes at a critical time in national plans to increase the generation of renewable electricity. So this is some blow to them. Right. Ireland has about 4.5 gigawatts of onshore wind power installed in just over 300 wind farms. There's two of them I know causing terrible destruction, and others as well. Under the Climate Action Plan, the capacity must be doubled to 9 gigawatts by 2030, and that's done in breach of Article 3.2 of the Strategic Environmental Assessment Directive 2001 204/2001 EC. That's the SEA Directive Article 3.1. They never did the assessment for our onshore wind. A spokesman for Wind Energy Ireland said, "It is a very detailed judgment and covers," well, I'm glad they admit it is, "and covers complex area of project development." No, it doesn't cover anything complex. There's nothing complex about being kept awake all night with a big tumble dryer running in your room. Sometimes it will remind you that there's a big heap of horses and carts going across a cobbled road. So the wind farm's up there. I'm not far from it here. Only 550 meters from here. And you'd imagine there was a big army with horses and carts going across cobblestones. That's the way it's a kind of this distant thing that there's something awful going on up there. What's going on? Not necessarily a war, more the carts going over with iron wheels going over the cobblestones. Or indeed sometimes a big tumble dryer. And then it lets a whine, and then in lovely weather there's a whine out of it as it's wee and wee. A whole summer last year it's at this. We are studying it closely. Well, you better study it closely because you'll be studying it with me before too long. We are studying it closely to see what implications, if any, it might have for the development of onshore renewable wind energy. It has no future. It has no future at all. To see what implications it might have on onshore renewable energy. There'll be none because I'll stop you doing it. You'll not get any more built. The Development of Housing, which is responsible for planning regulations, said it was considering the judgment in conjunction with the Department of the Environment and the Office of the Attorney General, but not for the reason of looking after the well-being and health of your people, but rather to see how you can defeat them, how you can bring the whole finances of the state to overcome it. And if they had to think of it again, they'd be in there with the state, with more barristers. Now, I hear very much, this trial, according to the paper, went on 51 days. And I hear now that the wind industry all got together and they tried to make it as expensive as possible. So if the case was lost, they'd get the costs and bankrupt these couples and these homeowners. And that'd teach a lesson to the like of me and make it difficult to do. So if they had to get the wrong judge, they could have been in serious trouble, and this is why everyone should empathise and understand why I do this. The wind farm is at the centre of the case, is at Ballyduff in Escorty County, Wexford, folks. Anyone from there? Comment underneath. Ballyduff in Escorty County, Wexford, owned by Mean Clockspur. Mean, MEENACLOGHSPRR. Mean Clockspur Wind. And has been operating since 2017. Mine has been operating from 2019. It received planning permission. Of course it did. We'll give a Bord Pernod and give planning permission for anything to do with green stuff. And we're being told several times they're in breach of the law and they ignore it. And they should be included in it. And I want you to think closely, is there any flaw in this case? Because I'm going to tell you afterwards. Winford since that. It received planning permission and with conditions around the level of noise measured at the nearest house. Now, this court case has said it doesn't matter what your conditions are. You can't cause nuisance. Who are they? Who is Bord Pleanála and Wexford County Council to judge what the noise levels are? Over 51 days of hearings, evidence was presented of the causes and frequencies of noise. See the money they had to spend, and this is why there want to be some help for people. Now, the weather and geographical features and the influence it and how it is perceived by people. Yeah, how this affects you. It affects you in a way that's not obvious. You can't just use the maximum noise. This is continuous noise. A big difference in a lorry going up the street and you hear it going by and it's gone. This is continuous noise. Lawyers at Mooney and Clockspur said their client would be judged on their compliance with the planning conditions on noise levels, which was not in question. So lawyers for the wind farm said their client should be judged on the compliance with the planning. That's the key. If they got the planning through, you could go to hell, no matter what it's for or how bad it is. Mr. Justice Egan disagreed, saying the court did not have to restrict its assessment to planning compliance. That's very important, folks. That is so important. The court, congratulations to it and to the groups and the judge and all. The planning thing is corrupt. It has no legitimacy anyway. It's all illegal. But in any event, they're not entitled to decide. They can't decide who wins a nuisance case maybe 5 years after the thing is built. That goes on the evidence of the day, irrespective of the planner. And in the case of the one granted here, it was two women, one of them from South Africa, that told me she never heard of the EIA directive, the SEA directive at all, and that there was no resources given to them to study it. She was just appointed in there with some kind of an environmental degree, and that's all she knew. And to think that she can decide what's a nuisance. She highlighted the lack of regulatory data in Ireland and relied on the UK Farms Noise Statutory Complaint Methodology for guidance. That's the judge. So she took the UK one. Miss Justice Egan acknowledged the wider significance of the case. This case concerns the production of renewable energy, which is clearly of vital importance to society. Well, there I disagree with you, Judge. It has no importance to society at all. Ireland's wind farms are net consumers of electricity if measured over a year. They're net consumers of electricity if measured over a year, and they cannot operate without fossil fuel or nuclear energy. They must have at least 35% of the grid from traditional sources until they can start to feed into the grid. Now, so the case could now on everyone who lives in it. So, right, now just to read what she said again. This case concerns the production of renewable energy, which is clearly vital importance to society and everyone who lives in it. Well, that's, you see, the green stuff. But we'll read on what she says. The fact that such activity was of public importance was not a defence. So there's only one defence to noise if it's not significant. You might not win against the state if it was a war or something like that, you know. But so that's the important point. You have to deal with this. Like in reality, if it was vital and it worked, you'd have to enter a deal with people to relocate them. You'd have to give them a lot of compensation. You'd have to buy them houses elsewhere and all of that. You just, no matter how important it is, you cannot destroy people's lives. Now, so the fact that such activity was of public importance was not a defence, she said. However, it might have some bearing on the final outcome, so on what she's going to do. The public interest must inevitably be a factor in the court's assessment of an appropriate remedy. So she's going to take into account the public interest. Well, I'd say what she's at there, she's balancing the public interest for renewable energy with the rights of the individual. And this is always the case. But whatever happens, it'll only take time, only time will tell. At the very least, it means that the generalized injunction ought not to be granted where the tailored injunction more suitably, where a tailored injunction more suitable to the particular interference held to constitute nuisance is warranted. So she's going to tailor it down. Well, I won't predict the judge's decision. But what she's saying there is maybe you could shut them down at night, and that'll take away their profit. They'll be broke. But they're broke anyway, so it doesn't matter. Current wind energy planning guidelines dated 2006 are widely accepted to be out of date. The Department of Housing published draft revised guidelines in 2019, but they were later withdrawn, partly due to disputes over the proposed guidance on the noise levels. The Climate Action Plan sets a timeline of the end of the year for completion. Now, folks, may I add a wee bit to that? That's that. But there's another case coming up right after this video. I'm on 22 minutes. You're going to have to see how we really have them caught. This is important for getting compensation. The judge is considering shutting them down at certain hours. How that's going to help, I don't know. We'll leave it in the hands of the judge. But right after this is going to be another article, folks, and that'll really show you how these are caught badly. Give me a thumbs up or a thumbs down. You'll probably get it. I'll put a link underneath on the Independent. But I have the ruling, and the ruling's available online, the full ruling, but many of you won't want to read it. So the thing about it is, we can't enjoy our property. We were enjoying our property. We can't enjoy our property, and it's for the rest of my life and the rest of those whoever follow on here. So that's not acceptable. And the thing about this ruling, it doesn't appear to apply to your house only. The way I'm fixed here, my farm is very long. It runs roughly north-south along the River Glide. And the wind farms are running alongside it, 5 of them. There was 7, I got them stopped down to 7. The wind farm runs parallel. So no matter where I go on my farm, there's one turbine 75 metres from my farm down at the north end. And right along here, they go round in a sort of a horseshoe shape to keep them away a bit. And then over here where I have a special little well up there, and up there it's only about 80 metres from my property. So when I'm up there doing work or doing anything, I have this thing going round over me with an awful noise. So it's not only your house and your living place, it's your enjoyment of the property generally, and to use it, particularly if it's in a quiet sort of an area. So folks, that's the good news. Now I'm going to come back now with something else on that, and we'll see you back soon. Please comment underneath what you think. If you think this is a wrong judgment, that we should have wind energy, no matter what annoyance it caused, that you say that too. But remember, you cannot generate any electricity without noise. That light there now is coming from fossil fuel plants, and that's a way off somewhere on its own. So up to now, the generation was away from people. Whereas even in Dublin there, down at the Pigeon House and down there, Poolbeg, that's away from people. They don't have to listen to the noise. The thing about wind energy, the noise is stuck beside the people who are where it's been generated, and then the electricity, whatever bit it is being consumed by people who are not suffering it. So that's why it's so very unfair. Folks, back, see you soon. Thank you.